Good evening, this is B. Nagesh, Additional Secretary Retired, Team IS Network. Today, we take a topic for discussion which is common to both GS2 and GS3. So, when preparing for the mains, what we suggest is going through the syllabus for all the four papers, all the four GS papers. Take out the things which are common between the papers. So, there's a lot of overlapping between the papers, between GS1, 2, 3, and 4. So today we have taken one particular topic which is common to both GS2 Federalism, GS3 Agriculture. The discussion of the question, the enactment of laws relating to agrarian reforms violate federalism. I repeat the question once again. The enactment of laws relating to agrarian reforms violate federalism. 200 words. So what the question is trying to elicit from you is, with the background of the recent agrarian reform laws which are passed by Parliament, whether it amounts to violation of the federal principle, whether it amounts to Parliament encroaching the sphere of the states, though we have the 7th schedule with a clear-cut division of powers between the Union and the states. So in this background, we analyze this question. Now, the passage of the three laws which are passed, which received the assent of the President recently on agrarian reform. Now, this has led to a chain reaction throughout the country. So, we give a brief introduction to the answer. We categorize the views of the government, we categorize the views of the opposition. Then we see whether the issue is constitutionally valid or not. Now, when the laws relating to agrarian reform were approved by the President recently, now Chhattisgarh, Maharashtra and Punjab have decided not to implement the laws on agrarian reform. Kerala and Punjab have decided to challenge the same in the Supreme Court. Now, what does the government say? What is the view of the opposition? Now, the views of the government. So, the government, when it piloted the bills for agrarian reform, the first important feature which it tried to project was reducing the influence of middlemen in the APMC. See, the middlemen who are cornering all the benefits and who come between the farmer and the purchaser, how they are knocking off the bulk profits and the farmer is left helpless. The middlemen or the dalalis and their role in the APMC. This is supposed to be fully reduced due to the laws on agrarian reform, in which the government is trying to promote direct transaction between the farmer and the buyer, so that the farmer benefits. This is the view of the government, and this is an important step in agrarian reform. The farmer is going to benefit with better price. He can negotiate the price for his agricultural produce with buyers and take the best offer without the middleman interfering. The second advantage quoted by government is with reference to contract farming. Now, in contract farming, after the farmer enters into a contract with the farmer, he can produce crops as per the contract with corporate investors for a mutually agreed remuneration. So the income is fixed for him, and even in the agreement, there is a provision for escalation. There's a the whole agreement is, like, what shall I say? It is foolproof, so that the farmer benefits by entering into agreement with the corporate authority, corporate investors. The third important advantage of the agrarian laws passed by Parliament is the farmer has got the freedom to sell anywhere. His activities are not restricted to the APMC. He can sell it anywhere, even outside. Now, the opposition. What is the view of the opposition? So the opposition says, even now, the first important thing the opposition is objecting to in the laws on agrarian reform, it says it is going to lead to corporatization of agriculture. Now, the farming sector is highly unorganized, and whether the farmer can wriggle out of an unfavorable contract, whether he can afford to fight with the legal bigwigs of the corporate industry. So this is one thing. This is one issue which the opposition is speaking of. The unorganized sector, the farming community is unorganized, and how the corporates, like they mentioned the specific thing of contract farming, how contract farming, when the farmer is not fully aware of his rights, how the corporates can drag the unwilling farmer to court, and whether the farmer has got the time, energy, and money to fight against the bigwigs. The second important objection which the opposition is levying is, see, the farmers, even now, even before the act came about, before the laws came about, the farmers could sell their agricultural produce outside the APMC after paying specified fees. And in fact, this contributed to a substantial portion of the state revenue. We give the example of Punjab. Now, Punjab and Haryana, they have fixed a market fee of 3%, rural development fee of 3%, and agent fee of 2.5%. All this put together goes to the state coffers. Now, if states are not permitted to levy fees, if states are not permitted to levy cess outside the APMC areas, Punjab stands to lose nearly 3,500 crores every year, and Haryana stands to lose 1,600 crores every year. So this is a serious thing which the policymakers have to keep in mind, how the present measure affects the state revenues. The present laws saying that states cannot levy fee outside the APMC area, if it is implemented, if it is brought into force, how it is going to hit the state revenues. I gave the example of Punjab losing 3,500 crores every year, and Haryana 1,600 crores every year. Now, with this background, we go to the constitutionality, that is whether the enactment of laws relating to agricultural reforms, do they violate federalism? In the first place, you see the distribution of subjects in the seventh schedule. So the seventh schedule categorizes the powers as in the union list, which is exclusive prerogative of the center, the state list conferring powers on the state legislatures, the concurrent list in which both the union and state can legislate. We take a particular entry in the state list: agriculture, agricultural education, research, water, irrigation and canals, land. These are the subjects which are in the state list. Now, when these subjects are there in the state list, whether Parliament is competent to legislate on a matter in the state list. Now, in one of the cases in the Supreme Court, the Union of India versus H.S. Dillon, 1972, it said constitutionality of parliamentary laws can be challenged only on two grounds. First, if the subject is in the state list. See, now Parliament has legislated on a subject in the state list. So it is a ground for challenging in the Supreme Court. The second grounds of challenge is if the laws violate human rights, if it violates fundamental rights. So this is a clear example of how the Parliament has encroached into the working of the state, or it has violated the state's jurisdiction. The second question we are asking is whether can Parliament pass a law on agricultural markets and subjects in the state list, violating the spirit of the Constitution. This is what we have just discussed. Further, you take the three laws which were passed, that is fixing remunerative price, the law on contract farming, and the third amendment to the Essential Commodities Act. Now, these agrarian reforms do not mention in the statement of object and reasons. See, every bill before it is presented in Parliament, there is a statement of object and reasons. That is why the bill has been introduced, the clause under which it is introduced, the reasons for it which is introduced. So now when we see these three bills, The constitutional provisions under which Parliament has power are not mentioned in these bills. So it's a very glaring lacuna. So it clearly shows how Parliament has tried to come into the sphere of the states. Now, in the S.R. Bommai case, S.R. Bommai versus Union of India, the Supreme Court laid down that federalism is a part of the basic structure. So by federalism, I mean the each authority exercising powers conferred on it by the Constitution. The Union list, Parliament alone can legislate. The state list, state legislatures can legislate. Concurrent, both can legislate. So when we analyze a question like this, we can bring it to notice that there is a violation of the federal structure. Like we can, like how the Supreme Court pointed out in the Union of India versus H.S. Dhillon, the constitutionality of a bill of parliamentary law can be challenged if it if the subject is in the state list. Now, Parliament has legislated on a subject in the state list. Parliament has no authority to legislate. Then, if the subject violates fundamental rights, these are the two issues in which you can challenge the constitutionality of any law in the Supreme Court. The grounds are laid out in this particular case. And we also mention how Parliament, by specifically legislating on a subject on the state list, as I said, in the distribution of powers, agriculture, agricultural education, research, water, irrigation, canals, and land, these subjects come in the state list. So Parliament passing a law on agriculture and agriculture related subjects on the state list, it violates the spirit of the Constitution. Further, we also remarked how in the statement of objects and reasons which accompany a bill when it is presented to Parliament, these three bills do not contain or do not indicate the constitutional provisions under which Parliament has got power. Finally, we concluded by observing the remarks of the Supreme Court in S.R. Bommai versus Union of India that federalism is a part of the basic structure. See, the Supreme Court has ruled that federalism is a part of the basic structure. And when federalism is a part of the basic structure, it implies that the different authorities, whether it is the union or the states, can legislate, can perform their functions strictly in accordance with the provisions of the 7th schedule. There cannot be any trespass by either authority. So this is how we analyze a question relating to enactment of laws relating to agrarian reforms violate federalism. So this is how, with the introduction, we briefly highlight how the government is supporting them, the reasons, how the opposition is opposing with reasons. Then finally, the constitutionality, whether Parliament is right in encroaching the sphere of the states. This is how your answer should be prepared for a 200 word. Thank you.